All right. Welcome back. We've we've got a change of plans for today. I mentioned that I was going to try to do the delete laws second amended complaint today, but I'm just not in the mood to deal with that kind of stupidity today. So instead, we're going to actually learn something. So this is, actually, even though we're not covering delete laws, this is related to something that he often talks about and gets completely wrong. So he often, and this is a common sovereign citizen First Amendment auditor thing. Um, there's a 2015 U.S. Supreme Court case called Rodriguez or U.S. versus Rodriguez, I think. Um, Either way, it's about extending traffic stops. And basically, it says, hey, in a traffic stop, the cops can't extend the stop in order to get a drug dog there or to do other things if they've got to complete the traffic stop for what they did. And if they haven't developed new probable cause for something else during that time, they've got to end the stop and let you go or arrest you, if that's what the stop results in. But either way, they can't extend the stop to fish for something else. So, and I should mention, you know, professional YouTuber that I am. For those of you who are new here, hi, I'm Joe. I'm a licensed attorney in the state of Utah. What we're dealing with today arises out of the state of Kansas. Don't go to Kansas, they suck. But yeah, so either way, after the Rodriguez decision, Kansas started doing what's been referred to as the Kansas two step. So basically, the Kansas Highway Patrol, specifically here, would complete their traffic stop. They'd take two steps away, and then, like Colombo, I is it? I think it's Colombo. It's a bit before my time. Turn around and say, "Oh, one more thing," you know, one more thing. And their argument was, "Hey, we ended our traffic stop. Now this is a consensual encounter. We didn't tell them they're free to go. They still think they're being stopped, but this is now a consensual encounter, so we can wait for that drug dog to come and sniff their car. We can ask them questions. It's consensual." And of course, if I were arguing this case, you know, uh, well, first off, it would be, in what world do you think this is consensual when you've pulled them over, you've ticketed them, you've taken two steps back, but you never said they're free to go? They think they're still detained. That this isn't hide the ball. If they are detained and you haven't said you're free to go, then they're still detained. But the traffic stop has ended. Their purpose for the stop has ended. So in order for them to continue the stop, it's I'd ask them on the stand, what was your probable cause for the second stop? What was your reasonable suspicion? You don't have any? Imagine that. So, yeah. So basically, the Kansas Highway Patrol was sued multiple times, and we got a joint decision from the U.S. District Court for the District of Kansas. I say a joint decision because like I said, they were sued multiple times. So this is a single written opinion in multiple cases. So we have the case of Blaine Franklin Shaw et al. So there's multiple plaintiffs versus Eric Smith in his official capacity as the superintendent of the Kansas Highway Patrol et al. So, against others as well, such as the individual troopers. And then we also have separate case. You notice there's Civil Action 19. So it's from 2019, 19-1343. And then we have Civil Action 20-1067. So one from 2019, one from 2020. And the 2020 is Mark Eric versus Eric Smith, once again. So not going to read the complaint, not going to read the motions to dismiss and, motions for summary judgment and all that. I'm just going to read the memorandum and order. And before I do that, I should mention the judge, the plaintiff's won, obviously, because it's an obvious constitutional violation. So obvious. And this is such a big decision, not a Supreme Court decision, but it's binding on the state of Kansas, their highway patrol. I'm surprised that Delete Laws hasn't talked about it because it bolsters his favorite case to get wrong. And the judge entered a permanent injunction, a permanent restraining order to, first of all, stop the Kansas two-step, but also has placed some affirmative obligations on the highway patrol to ensure they don't do it. So, and basically a permanent restraining order, that is a massive win for the plaintiffs, for the public, period. Courts do not give restraining orders lightly. And I'm not talking like a stay away order or whatever. I'm talking the injunction style restraining order. Even a temporary restraining order is, that's a big step for a court. But a permanent restraining order, that's massive. That's absolutely massive. And that just shows what a constitutional violation this has been. So with that, let's jump into, we've got here a 15-page memorandum and order. So let's do that. So on July 21st, 2023, the court held that in violation of the Fourth Amendment and Vasquez versus Lewis from the 10th Circuit in 2016, defendant, Highway Patrol, was responsible for a policy or practice which unlawfully detains motorists in Kansas, especially out-of-state motorists. They're alleged to specifically target Colorado plates and, to a lesser extent, maybe Missouri plates. So the defendant was responsible for a policy or practice which unlawfully detains motorists in Kansas, especially out-of-state motorists, without reasonable suspicion or consent, based on out-of-state residency and, to more than a minimal extent, based on travel plans that are not implausible or inherently contradictory. It also, and that's mentioned in the memorandum and order at docket 75. This is docket 122. So it also held that in violation of the Fourth Amendment, defendant was responsible for a policy or practice of using the Kansas two-step to extend traffic stops of motorists in Kansas without reasonable suspicion and without the motorists' knowing, intelligent, and voluntary consent. And we've got footnote 1, which says, because Jones retired, Jones, the previous superintendent of the Kansas Highway Patrol, So because Jones retired on July 1st, 2023, the court directed the parties to show cause in writing why it should not substitute Eric Smith, the current superintendent of the Kansas Highway Patrol, as defendant in this case. All parties agreed to the substitution, and on August 8th, 2023, the court ordered substitution under Rule 25D, Federal Rule of Civil Procedure. So, and see Hafer versus Mello, Supreme Court 91. When an official leaves office, successor automatically assumes his position in official capacity litigation. So that's why, even though these constitutional violations occurred under Superintendent Jones, Superintendent Smith, even though it was for all of 5 months, became the defendant. So, to remedy these violations, the court ordered that the parties show cause why it should not enter the injunction outlined in the order. The parties responded on August 3rd. August 3rd, August 21st, and August 28th, 2023. That's a kind of confusing date there. On August 30th, 2023, the court preliminarily overruled defendants' general objections that, 1, injunctive relief should be denied because plaintiffs failed to establish the absence of an adequate legal remedy for any potential future violation of their Fourth Amendment rights during a traffic stop. 2, the court did not properly apply the test for irreparable harm. And 3, the proposed injunctive relief was unduly burdensome and not narrowly tailored to the violations at issue here. So those were the defendants' 3 objections to the injunction. This order more fully sets forth the court's reasoning in overruling the objections to the injunction stated in defendant's response to the order to show cause why the court should not enter the proposed injunction, filed August 21st, 2023. We've got footnote 2. Many of defendant's objections simply rehash arguments that he made in his Rule 52 motion. Rule 52 is the summary judgment, which was filed on May 9th, 2023. In this regard, the court incorporates by reference its memorandum and order, which addressed those arguments. So, in addition, this order resolves the parties' competing arguments about the scope of the injunction, the documentation requirements for vehicle stops, and the supervisor training requirements. Scope of the injunction. This is where we start to get into the important bits. So even though the court never certified a class in this case, so it wasn't a class action lawsuit, although it very well could have been, defendants stipulated that any injunctive relief awarded to the named plaintiffs would benefit all putative class members without the certification of a class, i.e., any declaratory or injunctive relief which has been demanded would run to all persons similarly situated. Because of defendant's stipulation, plaintiffs agreed not to seek class certification for its proposed class, which its motion for class certification defined as follows: all persons in the United States who traveled in Kansas on Interstate 70, Interstate 35, US 54, or US 36 as a motorist or passenger who actually or appeared to be driving to or from Colorado in a vehicle with license plates from a state other than Kansas, who were stopped, detained by the Kansas Highway Patrol, and subjected to searches of their vehicles or persons by a canine, but were not subsequently convicted of a crime as a result of the stop, detainment, arrest, or search by the KHP. And footnote 3, the proposed class excluded defendants and their affiliates, parents, subsidiaries, employees, officers, agents, and directors. It also excluded judicial officers presiding over this matter and members of their immediate families and judicial staff. So, because defendant's stipulation was limited to the putative class, the court limits the scope of injunctive relief to plaintiff's proposed class at the time of the stipulation. And footnote 4, plaintiffs are the masters of their own class definition. And that's citing Evans versus Brigham Young University, 10th Circuit 2023, which says plaintiff cannot escape parameters of his own chosen class definition. And that was citing Thornley versus Clearview AI Inc., 7th Circuit 2021, which emphasized that plaintiff controls own class definition. So basically, because in this case, the plaintiff's proposed class included out-of-state motorists who were stopped in Kansas, this is limited in that it doesn't apply to Kansas motorists necessarily because they weren't in part of the proposed class. Now, what this is going to mean, though, is this is going to, I think, have a huge knock-on effect because, well, number one, Kansas motorists, they can't allege discrimination based on their state, but they can still say, hey, look, we've also suffered under the Kansas two-step. It still violates our Fourth Amendment, so we're suing now. And hey, there's precedents that it's illegal. But what's also going to happen is anyone who is convicted for something after their initial stop, when the officer took 2 steps away and turned back and said, one more thing, they're all going to be filing appeals now. Or post-conviction relief. This could very well open a floodgates for the Kansas courts. It's going to be a bloodbath. So plaintiffs argue that because the court overruled as moot their motion for class certification, that outdated definition of a proposed class should no longer govern. Even though the court did not formally certify a class, defendant's stipulation included the phrases putative class members and all persons similarly situated. And that was in the response to court's show cause order concerning class certification, which in which they said, if the court grants equitable relief to named plaintiffs, such relief would benefit putative class members without the certification of a class. In other words, any declaratory or injunctive relief which has been demanded would run to all persons similarly situated. So, plaintiffs do not explain how, absent reference to their proposed class definition, the court can determine the meaning of defendant's stipulation. Plaintiffs note that defendant broadly stipulated that any injunctive orders would bind all Kansas Highway Patrol troopers. The fact that an injunction would bind all KHP troopers does not mean that the scope of any injunction would apply beyond the putative class, i.e., individuals who were actually or appearing to be driving to or from Colorado in a vehicle with license plates from a state other than Kansas. And we have footnote 5. In addition to defendant's stipulation and plaintiff's proposed class definition, the court notes that plaintiff's proposed findings of fact and conclusions of law, filed on May 20th, 2023, support limiting the scope of injunctive relief to motorists who were or appeared to be driving to Colorado in a vehicle with license plates from a state other than Kansas. CEG, proposed findings of fact and conclusions of law, document 529, which says KHP targets out-of-state drivers for traffic stops and roadside detentions for canine sniffs. And also, more than hypothetical possibility that KHP will target plaintiffs, as actual or perceived out-of-state drivers for pretextual stops and detentions. Also, noting differential traffic enforcement practices for Kansas and out-of-state motorists. And also, KHP continues to train troopers that out-of-state license plates can be meaningful factor in reasonable suspicion under totality of circumstances, which that that right there should be a violation of the privileges and immunities clause of the US Constitution, because the actual right to travel, you have the right to be treated as a welcome guest, or you have the right to be welcomed as a new in-state resident. The, meaning they can't treat you differently because you're from a different state. We're all Americans. Being from Colorado in Kansas is not and can never be reasonable suspicion. And they also cite Vasquez and the need to abandon pretense that state citizenship is permissible basis to justify detention and search of out-of-state motorists. Also, the hypothetical risk of future injury because, in part, one, plaintiffs still travel through to and from Colorado and other states, and that they use Kansas highways to do so. Two, KHP stops out-of-state drivers at a highly disproportionate rate. And three, once stopped, KHP detains out-of-state drivers for canine sniffs at disproportionate rates. Also, there are ongoing violations because KHP targets out-of-state drivers for traffic stops and detains those drivers without reasonable suspicion. And finally, the end of footnote 5, KHP disproportionately targets out-of-state drivers. So you may ask, why does the Kansas Highway Patrol target out-of-state drivers, and especially Colorado drivers? It's because recreational marijuana is legal in Colorado. It's not in Kansas. Not even medicinal marijuana is legal in Kansas. None. Missouri, I don't believe has recreational, but they have medicinal, to my understanding. So Kansas is like, hey, if you're coming from Colorado, or you know, you probably have weed, and therefore we're going to pull you over and we're going to violate your rights. So as to the scope of the injunction, the court also notes that at the time the defendant entered the stipulation, plaintiffs demanded injunctive relief, which is broader than the relief the court finds is appropriate. Specifically, plaintiffs requested the following injunctive relief. 1. Enjoining the defendant Jones from continuing the policy, practice, and custom of prolonging detentions for canine searches without reasonable suspicion of criminal activity. 2. Enjoining the defendant Jones from continuing the policy, practice, and custom of targeting drivers with out-of-state plates in violation of the right to travel, protected by Article 4 of and the 14th Amendment to the United States Constitution. So that Article 4 would be either the Privileges and Immunities Clause or the Privileges or Immunities Clause. And I can never remember which one is which, but either way, let's say Privileges and Immunities Clause in Article 4, but then the Privileges or Immunities Clause would be in the 14th Amendment, because there's one there and one there. 3. Requiring defendant Jones to implement improved policies and programs with respect to training, supervision, monitoring, and discipline that will eliminate the policy, practice, pattern, and custom of suspicionless detentions and seizures. 4. Requiring defendant Jones to implement appropriate measures for supervision and discipline of KHP troopers who conduct suspicionless detentions and seizures. Five, requiring defendant Jones to implement appropriate measures to ensure that KHP troopers document 1. All canine drug searches, including the location, the basis for each such search, the residency and demographics, including the state issuing the license. And apparently I wasn't done with footnote 5, but we won't worry about that. I thought that was going to be footnote 6. So, including the state issuing the license plate of the vehicle of each individual stopped, regardless of whether the encounter is followed by the use of force, consent search, citation, warning, or arrest. And 2, all citations and arrests, including the location, the basis for each such search, the residency and demographics, including the state issuing the license plate on the vehicle of each individual stopped, issued, and or conducted as a result of a canine drug search, and to do so in sufficient detail as to permit supervisory review for compliance with Article 4 and the 4th and 14th Amendments. Then moving back up to the previous list, number 6, I wish they'd do an ABC list, an alphabetical and numerical instead of just Roman numerals and then Arabic numerals, but we're back to the Roman numerals. Requiring defendant Jones to implement appropriate measures to ensure that documentation of all canine drug searches is retained in a single up-to-date computerized database. 7, requiring defendant Jones to make publicly available data on all canine drug searches conducted by the KHP on a semi-annual basis, including information on location, the basis for each such search, the residency and demographics of each individual stopped. 8, requiring defendant Jones to monitor and audit canine drug search policies, practices, and customs to ensure that such searches comport with constitutional and statutory requirements, including by, among other things, periodically reviewing forms documenting these searches and analyzing data on such searches. So, next section, irreparable harm unless injunction is issued. Irreparable injury and the inadequacy of legal remedies are the bases for federal injunctive relief. And that's citing Weinberger versus Romero Barcelo, Supreme Court, 1982. Harm is irreparable if plaintiff can show a significant risk that he or she will experience harm that cannot be compensated after the fact by money damages. So, rephrasing that, if it can be fixed by money, the harm isn't irreparable. At least not necessarily. And that's citing Fish versus Kobach, 10th Circuit, 2016, which itself quotes Rodod Drilling Co. versus Siegel, 10th Circuit, 2009. So, adequate legal remedies foreclose injunctive relief. So, remember, legal in the civil context, legal means money. So, if before the courts were merged, there were courts of law and there were courts of equity. Courts of law were for money damages. Courts of equity were for injunctive relief, or basically the court making you do something or stop doing something would be equitable relief. Whereas the court making the defendant pay you, that's legal relief. So when it says adequate legal remedies foreclose injunctive relief, that basically adequate money remedies foreclose injunctive or equitable relief. That's Northern California Power Agency versus Grace Geothermal Corporation, Supreme Court, 1984. When an alleged constitutional right is involved, most courts hold that no further showing of irreparable injury is necessary. That's quoting Fish, which itself quotes Kikumura versus Hurley, 10th Circuit, 2001. Accordingly, while the court must engage in its traditional equitable inquiry as to the presence of irreparable harm in such a context, the violation of a constitutional right must weigh heavily in that analysis. Defendant argues that plaintiffs have failed to establish that legal remedies will not adequately compensate them for any potential future violation of Fourth Amendment rights. So you can just keep pulling them over and keep paying them off for violating their constitutional rights. That's what the defendant's arguing. That's when people say all cops are bastards, ACAB, this is what they're talking about. It's bullshit like this that leads to those sentiments. Stop violating people's rights, and people will complain about you a whole lot less. I mean, I try to be fair in my analysis. I tend to criticize the sovereign citizens and First Amendment auditors and the criminal dickheads a whole lot more on my channel, but I criticize bad cops too, bad policing, bad policies, and this has been a atrocious violation of the Constitution. It's bad policing. It's awful. So lest I'm sure the delete laws of the world have called me a bootlicker plenty of times. I'm criticizing the police here. Don't go to Kansas. They suck. Even if a violation of plaintiff's constitutional rights would give rise to discrete injuries that could be redressed through money damages, however, the threatened or ongoing violation of constitutional rights is sufficient to establish irreparable harm for purposes of injunctive relief. As the court previously pointed out, individual lawsuits against KHP troopers have not persuaded and evidently will not persuade the KHP to adopt permanent and comprehensive changes that are necessary to protect plaintiffs and similarly situated motorists from constitutional violations in the future. And quoting from the memorandum and order, docket 539, because of qualified immunity, damage suits under Section 1983 are especially unavailing in most cases. So basically what the court's saying here is, look, the cops don't care. Because they have qualified immunity, they don't care about damages. They don't care that by following KHP policy that, hey, yeah, do the Kansas two-step. You're covered. You're immune. You've got qualified immunity. So the existence of money damages, of a legal remedy, don't dissuade individual troopers from doing this, even though it is a constitutional violation, because hey, it's not out of my pocket. So because that legal remedy isn't sufficient to stop individual officers, injunctive relief is appropriate. Moreover, in this case, defendant avoided a trial of Section 1983 claims for an entire class because he agreed that any injunctive relief awarded to the named plaintiffs would benefit all putative class members without the certification of a class, i.e., any declaratory or injunctive relief which has been demanded would run to all persons similarly situated. So basically, it's, hey, look, the defendants, the KHP has already agreed that in order to avoid certifying a class for a class action, and any relief for the plaintiffs in this case uh, will flow to future, to all putative plaintiffs. So it's like, well, then if the relief is money, are you just going to, be handing out Benjamins to Colorado drivers as they drive across the border and say, hey, you're going to need this, trust me? That's not how it works. The court therefore overrules defendants' objection that plaintiffs have adequate legal remedies for the threat of future constitutional violations. Defendant argues that this court's finding of irreparable injury violates the well-established principles of comity and federalism because the proposed injunction requires continuous federal court supervision of a state law enforcement agency. To obtain injunctive relief against a state law enforcement agency, a party must show the traditional prerequisite of irreparable injury. That's citing City of Los Angeles versus Lyons, Supreme Court, 1983. Past exposure to illegal conduct does not in itself show a present case or controversy regarding injunctive relief if unaccompanied by any continuing present adverse effects. That's O'Shea versus Littleton, Supreme Court, 1974. In addition, absent irreparable injury, which is both great and immediate, the need for a proper balance between state and federal authority counsels restraint in the issuance of injunctions by federal courts against state officers engaged in the administration of its state's criminal laws. And we've got footnote 6. Neither Lyons nor O'Shea delineate what must be shown to make an irreparable injury great and immediate. In O'Shea, the Supreme Court used the great and immediate language in the context of addressing an issue of abstention under Younger versus Harris. Under Younger, federal courts must abstain from exercising jurisdiction to interfere with state proceedings if, 1, there is an ongoing state criminal, civil, or administrative proceeding, 2, the state court provides an adequate forum to hear the claims raised in the federal complaint, and 3, the state proceedings involve important state interests, matters which traditionally look to state law for their resolution or implicate separately articulated policies. We're all experts on Younger here, aren't we? When Younger's 3 requirements are met, abstention is mandatory unless one of the 3 exceptions applies. The prosecution was 1, commenced in bad faith or to harass, 2, based on a flagrantly and patently unconstitutional statute, or 3, related to any other such extraordinary circumstance creating a threat of irreparable injury, both great and immediate. That's Phelps versus Hamilton, 10th Circuit, 1995. It appears that any heightened requirement for plaintiffs to establish great and immediate irreparable injury applies to injunctions that interfere with ongoing or pending state criminal prosecutions where Younger is potentially implicated, rather than injunctions that impact law enforcement officer behavior in future investigations. So basically, what that second paragraph of the footnote says is essentially, look, under Younger, if the plaintiffs here were still litigating their criminal case, Younger would apply, and it would be inappropriate for the federal courts to interfere because they can raise the constitutional issue in the criminal case. The state court, the state criminal court can decide that. I mean, as defense attorneys, that's what we do. We raise Fourth Amendment claims all the time as defenses to prosecution. So in this case, though, I'm going to assume we're beyond that. The prosecutions have ended. So this is, it impacts law enforcement officer behavior in future investigations. So this is saying, hey, you can't do this in the future, not this is a defense to my criminal case. Do you see the difference? So in tailoring remedies, the preferred course is to preserve as much discretion for state administrators as possible. But where constitutional rights have been violated, comity does not require or even permit a federal court to countenance those violations. And that's from Duran. The court previously outlined the highly disproportionate rates at which the KHP stops and detains out-of-state drivers based on inappropriate criteria. The KHP's routinely improper use of the Kansas two-step and plaintiff's testimony that they continue to travel through Kansas on Kansas highways and KHP troopers will detain them in the future. And footnote 7. Contrary to defendant's objection, the court has not assumed, without evidence, that KHP routinely engages in unconstitutional policing. So, I hate to keep bringing him up, but he's the reason I wanted to cover this. And, you know, I should also give a shout out to Steve Leto, Leto's Law. I first saw about this. He covered it on his channel. He did not read the decision, though. He just covered the news articles. But in delete laws versus, De Castro versus LVMPD, his Monell supervisory claims, the pattern and practice, he just alleges, look, they discriminate against me. They have a pattern and practice of discrimination. My evidence, I don't have to plead evidence. I don't have to provide any, but we're not seeing it here since this is just the decision. But the court says, the court previously outlined evidence of the highly disproportionate rates at which the KHP stops and detains out-of-state drivers based on inappropriate criteria. So delete laws, if you're watching this, not legal advice, you might go into this website or into this case. Let's see. It's in the memorandum and order, document number 539 at 27 and 57 through 58. As an example of how to set forth that actual pattern and practice. You know, just an idea. Unlike Lyons and O'Shea, plaintiffs here have shown that they and similarly situated individuals are at risk of recurring constitutional violations because they are simply traveling in a vehicle with an out-of-state license plate on Interstate 70 in Kansas. And they're citing Lyons again, which says, to prevail on a claim for injunctive relief against police use of chokehold, plaintiff would have had to allege that he would have another encounter with the police and that either one, he would illegally resist arrest or detention, and 2, the officers would disobey their instructions and again render him unconscious without any provocation. And then in O'Shea, no case or controversy because threat to plaintiffs was not sufficiently real and immediate to show an existing controversy simply because they anticipate violating lawful criminal statutes and being tried for their offenses. So that's differentiating O'Shea and Lyons. The likelihood that a specific plaintiff or similarly situated individual will be stopped and subject to an extended encounter based on a trooper's coercive tactics may not be high, but KHP's continued routine use of such tactics makes it sufficiently likely that KHP again will violate the constitutional rights of plaintiffs or similarly situated individuals during traffic stops. That's citing Ortega Melendres versus Arpaio. God, what a mess he was, Sheriff Joe. And that's unsurprisingly from the District of Arizona in 2011. And it says, the likelihood that any particular named plaintiff will again be stopped in the same way may not be high. However, if Maricopa County Sheriff's Office detains people, as they claim a right to do, without reasonable suspicion that they have violated essential elements of a criminal law, either state or federal, exposure to that policy is both itself an ongoing harm and evidence that there is sufficient likelihood that plaintiff's rights will be violated again. And I just can't believe that Joe Arpaio, well, we have a right to detain people without reasonable suspicion. That's annoying. But yeah, so Maricopa County under Joe Arpaio, we have a right to detain people without reasonable suspicion that they violated the law. What the hell is the Fourth Amendment for? How was he sheriff for 30 years or 40 years or 800 years or whatever? He was a walking, talking constitutional violation. The court therefore overrules defendant's objection that plaintiffs have not established a risk of irreparable harm. Next up, objections that injunction is unduly burdensome and not narrowly tailored. The court preliminarily overruled defendant's objections that the proposed injunctive relief is unduly burdensome or is not narrowly tailored to the violations at issue here. We have footnote 8. Specifically, defendant objected that the scope of injunction is too broad because it places the court, 1, in the position of micromanaging the KHP as to traffic stops, documentation of such stops, personnel and works assignments, work schedules, record creation and retention, internal reporting requirements, and annual training requirements, and 2, acting through the special master in the position of reviewing virtually every traffic stop made by KHP. Defendant also objected that it is overkill to require that troopers inform individuals verbally or in writing that they have the right to refuse to consent to a search, and if consent is given, they have the right to revoke it at any time. We'll talk about that in a bit, I hope. As explained, Defendant has not proposed any alternatives which would be less burdensome or more narrowly tailored, yet achieve substantially the same goals. The court therefore cannot properly evaluate whether any particular burden is undue in light of the constitutional principles which must be vindicated in this case. In addition, as to defendant's objections about the purported burdens of the injunction, he offers no evidence to support the assertions that the injunction would impair troopers' ability to do their job, would be a logistical nightmare, and would require a significant number of additional troopers and significant additional funding. Likewise, defendant offers no evidence to support his assertions about the KHP's ability to increase its funding, its current staffing difficulties, or its ability to pay the costs associated with a special master. And footnote 9. To the extent defendant argues that the appointment of a special master or monitor is unduly burdensome, the court has partially addressed this objection by modifying the proposed injunction so that instead of a special master, KHP reports directly, at least initially, to the court. To the extent that a monitor or other expert is eventually required to ensure KHP compliance with the injunction, KHP will be liable for such expenses because they are necessary to implement the remedy for the agency's constitutional violations established in this case. CEG Melendres versus Arpaio, again, District of Arizona 2013, where defendants to pay reasonable fees and costs to monitor. Also, Floyd versus City of New York, Southern District of New York 2013. City to pay reasonable costs and fees to monitor his staff and experts he retains. Likewise, to the extent that defendant objects to increased staffing costs, the court has partially addressed this objection by modifying the proposed injunction to substitute a supervisor training requirement for the prior proposed requirement that all supervisors work the same shifts and hours as the troopers they supervise. Where was that? Okay. And going back, can't remember. So, quoting the defendant's response, KHP, this is an assertion from KHP. KHP lacks the ability to unilaterally increase its funding and is experiencing the same recruiting difficulties reported by many law enforcement agencies. And it cannot even fill current vacancies, let alone the additional positions that would be required to comply with Section 5 of the injunction. And also requiring KHP to provide any and all information and data demanded by the special master and to participate in various outcome assessments, compliance reviews, and audits will place an undue burden on an already understaffed agency, and no record evidence supports the conclusion that KHP has sufficient funds to pay all fees, costs, and expenses of the special master without diverting said funds from other legitimate law enforcement purposes. Well, how about this, KHP? Let's just say I'm driving through Kansas and I get pulled over and I get fined $500 for speeding. Because as we've already established, Kansas sucks. Don't go there. I don't have the additional funds in my budget to pay that $500 fine. Do you know what? Let's just say Judge Webster or Judge Crum or one of the judges we watch on YouTube. Let's just say Judge Webster. I say, Judge Webster, I don't have $500. I have a fixed budget and it's already all accounted for. So you can't fine me $500. You can just go to hell. You do not get a penny from me. Because it's not in my budget, I don't have to do anything you say. What will Judge Webster say to me after she finds me in contempt for telling her to go to hell? She'll tell me, this is more important. You can cut back somewhere else because I've fined you $750 now. So, what's the appropriate response to KHP saying, we just don't have the money? Then find the money. Go to the Kansas legislature and say, increase our funds because we have violated out-of-state drivers' constitutional rights. And the federal court has said, we need to do this to remain in compliance. So we need an increase in budget. And if the Kansas legislature tells them to get lost, they can tighten the belt somewhere else. They can cut the superintendent's salary to pay for it. They can tell the supervisors, hey, you need to spend an hour a day out of your time working on this. And drop some other activity that you were doing previously for that hour. Find a way. You guys have been violating the Constitution systematically. And now you're trying to cry poverty that, oh, poor us, we know we violated the Constitution, but that's not our problem. So we shouldn't have to fix it. This is why people hate you. Absent such evidence or specific proposals that are more narrowly tailored to remedy the constitutional violations, the court overrules defendants' objections that the injunction is unduly burdensome and overly broad. Defendant argues that injunction requires KHP troopers to take steps beyond what is legally required to obtain an individual's voluntary consent to search. To be sure, to obtain voluntary consent, a law enforcement officer is not required to affirmatively inform an individual, verbally or in writing, that he or she has the right to refuse to consent to a search, and that if consent is given, that he or she has the right to revoke it at any time. Footnote 10. See Schneckloth versus Bustamante, Supreme Court, 1973. Voluntary consent does not require knowledge of right to refuse consent. And U.S. versus Ledesma, 10th Circuit, 2006. By itself, officer failure to tell suspect she is free to leave does not make encounter non-consensual. U.S. versus Bradford, 10th Circuit, 2005. Officer not required to tell suspect she does not have to answer questions or that she is free to go. So it can be obnoxious. We've seen sovereign citizens, how obnoxious they are. But ask, am I detained or am I free to go? That don't be obnoxious. But also, cops, highway patrol, KSP, KHP, don't play games. If they're not detained, don't make them think they are, especially after they've asked. If they're detained, tell them, yes, you are detained. If they are not detained, tell them, no, you are not detained when they ask. But then don't get upset and view it as probable cause when they say, all right, goodbye. Because if they're not detained, they are free to go. And not sticking around when you're not detained is not probable cause. So even so, the court has broad remedial powers to craft injunctive relief to remedy constitutional violations. That's Milliken versus Bradley, Supreme Court, 1977. Once a constitutional violation is established, remedial decrees may require actions that the Constitution does not independently require if those actions are necessary to correct constitutional deficiencies. That's Duran versus Carruthers, District of New Mexico, 1988, citing Green versus County School Board, Supreme Court, 1968. And then Milliken and Gilmore versus City of Montgomery, Supreme Court, 1974. Yeah. Courts order injunctive relief not simply to prevent isolated instances of misconduct, but to remove the threat to constitutional values when a state or local law enforcement agency suffers from a persistent pattern of police misconduct. That's an awfully nice way of saying it. They suffer from a persistent pattern of police misconduct. I'd call it they're dickheads violating your constitutional rights. And that was Alley versus Medrano, Supreme Court, 1974, and Battle versus Anderson, 10th Circuit, 1983. The court must be sensitive to the state's interests, but it nevertheless must not shrink from its obligation to enforce the constitutional rights of all persons. That's Brown versus Plata, Supreme Court, 2011, quoting Cruz versus Beto, Supreme Court, 1972. See also Swan, Supreme Court, which says, if state authorities fail in affirmative obligation to uphold federal law, judicial authority may be invoked. As explained before, in violation of the Fourth Amendment, defendant is responsible for 1. A policy or practice which unlawfully detains motorists in Kansas, especially out-of-state motorists, without reasonable suspicion or consent based on out-of-state residency, and, to more than a minimal extent, based on travel plans that are not implausible or inherently contradictory. And 2, a policy or practice of using the Kansas two-step to extend traffic stops without reasonable suspicion and without knowing, intelligent, and voluntary consent of the motorists. Injunctive relief is necessary to remedy this pattern of trooper misconduct. The court therefore overrules defendant's objection that the injunction imposes requirements beyond what is constitutionally required. Defendant objects that the injunction creates the potential for inconsistent decisions in civil and criminal matters as to whether a violation of the injunction is also a constitutional violation, but does not explain specifically how the injunction creates such a risk. As explained elsewhere, the injunction is part of the remedy for past constitutional violations and an attempt to prevent future constitutional violations similar to the ones which plaintiff established in this case. A violation of the injunction, e.g., a trooper's failure to notify a motorist of the right to refuse consent, does not necessarily establish a constitutional violation. So, violating the injunction isn't necessarily violating the motorist's constitutional rights. It's violating the injunction. It's violating a court order. Likewise, compliance with the injunction does not guarantee the absence of a constitutional violation. You still, even if you comply with the court's order, you still might violate their constitution some other way. You may have stopped them on some other pretext. You may have questioned them after they requested a lawyer and they were in custody. You know, there's lots of you may have denied them a lawyer. You may have flogged them with wet celery in violation of the Eighth Amendment. Because the injunction does not necessarily result in a full constitutional inquiry or evidentiary hearing on individual traffic stops, as a court in a criminal matter may conduct for a suppression hearing, the risk of inconsistent decisions appears to be low. And that's basically what I mentioned when we were talking about Younger. The a court can conduct a constitutional inquiry for a suppression hearing. That's where you do it if the criminal case is ongoing. Younger says it's inappropriate for the federal court to step in almost all situations when there's the ongoing criminal case. So, documentation requirements. The court proposed an injunction that would require KHP troopers to document any stop in which a trooper detains a vehicle and its occupants to initiate inquiry into a traffic violation. Defendants argue that this requirement is overbroad because it requires documentation of virtually every traffic stop, including when a motorist is not detained and without regard to whether the motorist receives a ticket, a written warning, or a verbal warning. But hang on. Virtually every traffic stop, including when a motorist is not detained. If you stop them, you've detained them. Otherwise, they're not stopped. Now, there may be traffic encounters that you may be, helping them. Let's say that, they've got a flat tire and they're pulled over, and that's not a detention, but God. Plaintiffs argue that the documentation requirement should apply to stops of both out-of-state and in-state motorists. Even though the proposed injunction does not directly protect motorists with Kansas license plates involved in KHP traffic stops, documentation from all traffic stops, including those of in-state motorists, appears to be potentially useful to determine whether KHP has instituted adequate measures to protect the constitutional rights of motorists with out-of-state plates. That makes sense. How can you know that out-of-state motorists aren't being treated disparately from in-state motorists if you don't keep statistics for both groups? So that makes sense. Plaintiffs maintain that KHP already documents all traffic stops and that it could easily provide spreadsheets containing such data. Defendant does not deny that it could provide the requested data, but states that KHP is reviewing to determine if it can easily do so. Because documentation from all traffic stops has some relevance to the targeting of motorists with out-of-state license plates, and defendant has not shown that providing the data is burdensome, the injunction will require KHP troopers to document any stop in which a trooper detains a vehicle and its occupants to initiate inquiry into a traffic violation. Because the KHP already documents all traffic stops, this order prevents it from ceasing to do so. Supervisor training. The parties agree that supervisor training would accomplish the same purpose as the court's proposed requirement that all supervisors work the same shifts and hours as the troopers they supervise. What good is a supervisor working the day shift for those troopers working the night shift? It doesn't make sense. The court agrees and finds that a requirement for supervisor training shall be incorporated into the injunction as follows. Within 30 days of the effective date of this injunction, the KHP shall create and present to plaintiffs for approval a revised training curriculum and testing protocol for all supervisors at the rank of sergeant and above. This curriculum shall address proper communication standards, how to monitor troopers' actions, including reviewing troopers' reports, deficiencies in troopers' conduct in the field, and supervisors' obligations under this injunction and the U.S. Constitution. Within 45 days of the effective date of this injunction, the parties shall meet and confer about any objections to the proposed curriculum and submit an agreed curriculum for the court approval, or to the court for approval. Within 60 days of the approval of the curriculum, KHP shall provide all supervisors at least 8 hours of training as described above. Beginning 1 year after the effective date of this injunction, KHP shall provide all supervisors at least 8 hours of annual in-service training on these topics. The KHP shall institute a testing protocol which satisfies the court that each supervisor has mastered the required subjects. It is therefore ordered that on or before November 9th, 2023, the parties shall submit an agreed permanent injunction which is consistent with the court's rulings on the plaintiff's request for injunctive relief. In the event that the parties cannot agree on the form of the injunction, they shall file no later than 5 p.m. on November 9th, 2023, the competing versions of the injunction and an agenda of any unresolved issues which the court can address at the status conference on November 14th, 2023, and that's November 1st, 2023, by Judge Catherine Raytil. So, yeah, I'm cheap, so I'm not going to buy the permanent injunction that was entered on November 20th, but either way, let's see. So, yeah, basically, that's what we've got. So, they can't do it anymore. No more Kansas two-step, at least as far as out-of-state drivers, especially Colorado drivers. Trust me, there's it violates the Constitution for Kansas drivers as well. They I'm sure it will be ruled as such at some point, likely by the Kansas Supreme Court. And if they don't do it, a federal court, because it's awful. But they're going to have to start. They're going to have to do some training. They're going to have to stop doing it. They're going to have to. There were the affirmative that they have to inform the drivers that they have the right to refuse a search. They have a right, if they've granted the cops request a search, to revoke consent to search. They have, if I remember right, the cops have to tell them when the stop is ended that they are free to go, as an affirmative way to stop the Kansas two-step. It's we're done. You're free to go. But I mentioned I was going to come back to it, the revoking consent to search, because that's on Delete Law's Fifth Amendment card. Because he thinks it's a galaxy brain move to say, yes, you have the right to search. I consent to you searching. And then once they start the search, haha, I revoke consent. You get out of my car, you dirty pig. And that is stupid. Just don't grant consent. Don't grant consent. Because if they find something in that period, you're screwed. If you don't grant consent in the first place, they're not going to find anything that they wouldn't have been able to find without consent. So just don't grant consent. It's that easy. Shut the fuck up. Don't grant consent to search. Fifth Amendment, done easy. So with that, I hope you actually learned something today. We don't always do crazy, even if it's tied in with crazy somehow, but and we don't always lick boots, because as I've mentioned, at least off of YouTube, I'm quicker to criticize police than I am to criticize criminals, because I hold police to a higher standard. And frankly, that when they're violating the Constitution this blatantly and this often and arguing in court, well, you should let us keep violating the Constitution. It really pisses me off. And this was the right decision from the judge. So with that, thanks for joining me. Hopefully tomorrow I won't shudder and cringe, and I'll actually manage to do the Delete Law's second amended complaint, as awful as it's going to be. So thanks for joining me. Do the YouTubey stuff, like, share, subscribe, and I'm out of here. Bye-bye.